Hey there, my name is Matt McClintock. I'm an estate planning attorney in Colorado. I have a law firm called Evergreen Legacy Planning. And for reasons I'll get to in a second, I wanted to prepare this quick video on what the heck a Clayton election is and how it works. I have a lot of colleagues around the country, and based on a former life, I get a lot of questions from other estate planning attorneys on specific legal issues and legal strategies. And so it's my hope that through this video and maybe other videos that I do, I can provide some content that helps people up their game in practice. So, quick word about me. Um, I've been an estate planning attorney for 20 years, 10 years of which were spent doing an awful lot of teaching continuing legal education to other estate planning attorneys all around the country. So, teaching the law to lawyers, that's really been my background for about 10 of the last 20 years. I'm a Colorado transplant. I'm here in Evergreen, Colorado, just west of Denver. But we also have a national law practice. Our main office is here in Colorado. But we also have an office in Newport Beach, California. Hopefully, like you, I appreciate succinct, actionable content. And so that's my objective with this video and with other videos that we do in the series. I also just love collaborating on interesting projects. So, quick disclaimer, because I'm a lawyer here, the information in this presentation really is offered for general educational purposes only. Honestly, the intended audience for this would be other attorneys who are curious about estate planning matters, or estate planning attorneys who simply have some questions about how specific strategies work. This is not intended for general consumer audience, although I understand you might just be somebody who's curious about this, and that's fine. But understand that it's not my intent for us to constitute any legal advice with this presentation. And this presentation, or you're listening to this presentation, does not constitute or create any attorney client relationship. It really is critical that you always consult a licensed attorney before you make any decision concerning your estate plan or, frankly, any other legal matter. Now, the content of this presentation may constitute attorney advertising in some jurisdictions, even though that's really not my intent. I'm offering this information really to help other attorneys better understand the topics that I'm covering in this presentation. This presentation is certainly property of Evergreen Legacy Planning, LLP, and we are solely responsible for the content of this presentation. All right, let's get that out of the way. So, what is a Clayton election? Quite simply, the Clayton election is a tax election. It's simply a decision that gets made by a fiduciary on a decedent's federal estate tax return. That's referred to as a Form 706. Now, the assets of the decedent that get listed on Schedule M of 706, those are the assets that we're taking the unlimited barrel deduction on. So we could have a trust, we could have a trust with its assets, or we could have assets outside of a trust. They get listed on Schedule M. Those assets are elected for the marital deduction. Any trust or any assets that are not listed on Schedule M, but are listed on something else, on some other schedule on the decedent's estate tax return, then that's not marital deduction property. That's property against which we allocate the decedent's remaining estate tax exemption, subject to the laws at the time of their death. So I think it's often easiest to understand the Clayton election in context of other elections that are out there, other options that are out there. So there are a few what we refer to as mandatory formula approaches. And this is language that you'll often find in a will or in a revocable living trust. One option is referred to commonly as the fractional marital formula. And what that language does is it solves for a fraction or a percentage of the decedent's gross estate, and then that fraction gets applied to the assets in the decedent's estate to transfer assets either into the marital deduction trust or the credit shelter or bypass trust. Another option is called the pecuniary marital formula. It has formula language, but instead of solving for a fraction or a percentage, it solves for a specific fixed dollar amount. And then the trustee or the personal representative selects assets that are equal to the value of that pecuniary number that we solved for, and then they simply transfer those assets to the marital trust or the marital share, and the remaining assets would go to the non-marital or bypass credit shelter trust. And then the kind of the inverse of that is a pecuniary credit shelter or credit or bypass trust, where instead of solving for a dollar amount to fund the marital trust, we solve for a dollar amount to fund the credit shelter trust. A lot of nuances there, not going to get into it. There are other problems with pecuniary formulas, including this weird thing called Keenan gain, which we could get into in another presentation. But for now, let's just kind of hold it there. You got some mandatory formulas. That's pretty traditional estate planning approach. I think we can do a lot better than that. One thing that's interesting about any mandatory formula, whether it's a pecuniary or fractional gift, is that the marital gift to the surviving spouse, the property from the decedent passes to the surviving spouse, can be in any kind of form that qualifies for the unlimited marital deduction. Now, here I'm assuming that we've got a United States citizen decedent and a United States citizen surviving spouse. Not going to get into the planning for non-citizen spouses. That's, again, another topic for another time. But so long as the gift either outright to the spouse or in some kind of trust that qualifies for the marital deduction, you can do that with any of these mandatory formulas. Now, one of the really popular methods that's out there, I'm not a big fan of, frankly, it's called the disclaimer approach or the disclaimer method. What that does is that takes all the decedent's estate, the property that passes to the surviving spouse. The surviving spouse receives that property, but if the surviving spouse executes what's referred to as a qualified disclaimer in a way that satisfies all the requirements of the Internal Revenue Code, those disclaimed assets can go into a trust for the benefit of the surviving spouse, but it's a trust it's effectively a credit shelter trust. So it's a trust that we use the decedent's estate tax exemption on. Now, there are specific statutory requirements under Internal Revenue Code Section 2518 that tell us exactly what we need to do in order to qualify our disclaimer. But one of the reasons, and there's several reasons actually, I don't like disclaimers, and here's why. They usually, maybe not usually, they often fail because there are some technicalities that we can get hung up on. If we're not careful, we can blow it. First of all, there is a strict 9-month deadline. The surviving spouse has 9 months from the decedent's date of death in order to execute the qualified disclaimer. If they don't do it within 9 months, that you can't make a disclaimer. Any kind of gift after that would be a taxable gift by the surviving spouse. You don't get an extension. It's not like you're 706. You can't get an extension. There are no exceptions, no excuses. You miss the deadline, you've blown it. Now, what happens probably more often than not is that the surviving spouse receives some kind of monetary value from the property and then seeks to disclaim that property into the trust. They've used assets from the account and then they want to disclaim that account. You can't do that. That makes it a taxable gift at that time. So the spouse can't receive any benefit from the property before disclaiming. They can disclaim into a credit shelter trust, and that trust provides benefits for the spouse. But if the spouse receives benefits before disclaiming, they can't disclaim those assets. Also, this is a little wrinkle. It gets kind of weird, but the spouse has to not only comply with Section 2518 of the tax code, they also have to comply with all provisions of their applicable state law. So there may be a disconnect between what the state law requires and what the federal tax code requires in order to make a qualified disclaimer. They got to run those traps and make sure they get that right. Otherwise, it's not going to work. And there's also this other emotional aspect of it where sometimes the surviving spouse just fails to wrap their head around the idea of a disclaimer. They say, well, they kind of emotionally think, well, I need these assets. I need control over them. I need to be able to enjoy these things. They don't fully understand that the assets can pass into a credit shelter trust for their benefit. They can be the primary beneficiary. They can even be the trustee of that trust. But they think that ownership is required, and so it's hard for them to get their heads around that. So there are a lot of moving parts that have to happen, all again within 9 months or decedent's date of death. So here's how a Clayton election works and why it's my preferred approach for in most circumstances. Certainly some exceptions like anything else, but by and large, the Clayton election is my go-to approach for marital deduction planning for married couples. Here's how it works. All of the decedent's property gets allocated to a trust that will qualify for the marital deduction if and only if the election is made on the decedent's estate tax return. You don't make the election, it's not a marital deduction. Still goes into a trust, and the trust would qualify as a marital deduction trust, but the election has to get made on the estate tax return. The decision to make the election is determined by a fiduciary. So it's either the trustee of the trust or the personal representative of the decedent's estate, the executor under the will, if we're in a probate situation. Um, it's kind of my preferred approach is to not have that decision made by the surviving spouse. Now, the Clayton case did allow the surviving spouse to make that election. I think just kind of for purposes of being objective and kind of maybe out of an abundance of caution, I prefer having a trust advisor. Some jurisdictions refer to it as a trust protector. Maybe the CPA or some special independent trustee make the election and sign the estate tax return for a decedent. And then what happens is the assets that are allocated to Schedule M on the decedent's estate tax return, those are the assets that are subject to this Clayton election. It's simply Clayton is the case that gave us the strategy that allows the assets to go into a trust for the spouse and then have the trustee elect to have that trust treated as a marital deduction trust. Now, here's part of the power of the flexibility here. Unlike the mandatory formulas, which solve for a specific dollar amount or a fraction, the trustee or the personal representative making the election on the return, they can elect specific assets, specific fraction, a specific portion of the decedent's estate, and they can just be just a lot more flexible in how the tax return gets filed and the gifts that get, the allocations that get made on that schedule. Now, importantly, I mentioned on the mandatory formulas that the gift of the surviving spouse can be any form of a gift so long as it qualifies for the marital deduction. That is not true with the Clayton election. The Clayton election requires a Q-tip trust for the surviving spouse. And just a quick aside, that stands for Qualified Terminable Interest in Property. It's a special provision under Section 2056B7 of the Internal Revenue Code, and it's a trust for the benefit of the surviving spouse, has a few other requirements built in there, but it's a specific type of fairly protective trust for the surviving spouse in a way that qualifies for the marital deduction. So let's look at a few pros and cons real fast. As I mentioned before, maximum flexibility. The fiduciary gets to decide how much of the decedent's estate tax exemption to use when it's the most relevant. The tax laws certainly change. The value of the assets that comprise the decedent's estate may change pretty dramatically between the time the client does the planning and the time the client actually passes away. So provides a lot of flexibility. Second look after the decedent passes away. The property that gets set aside in this Q-tip trust for the benefit of the surviving spouse usually is the trustee and can be the only one who can be the beneficiary during their lifetime. So the assets are more protected for the surviving spouse. And the Q-tip trust can be designed in a way that protects the inheritance for the future generation as best we can. In a lot of cases, surviving spouse who does not have the protection of a Q-tip trust, the surviving spouse, if they just receive the property outright in their individual name, if that surviving spouse later remarries, they don't enter into a prenuptial agreement, they end up commingling those assets with a new spouse, and then our surviving spouse predeceases the new spouse. That creates an opportunity for the beneficiaries of our decedent to be accidentally disinherited just by failure to think through the plan. So Q-tip trust is extremely protective as far as that goes. The surviving spouse can hold what's referred to as a limited power of appointment over assets, either in the bypass trust or also even in the Q-tip trust. So depending on the strategy objectives, the surviving spouse can kind of finesse, if you will, the estate down the road. Doesn't have to have that, but it's another option. And the fiduciary who makes the election, again, if we're using an independent fiduciary, theoretically it's less emotional. It creates an opportunity for an objective analysis of the law and the tax at the time. It does require, so the Clayton election does require a 706 to make the marital deduction election. And so that also creates an opportunity for the surviving spouse to take advantage of what's referred to as portability. Again, that's probably another topic for another time, but allows the surviving spouse to claim the unused estate tax exemption of our decedent. Critical planning strategy that just needs to be taken advantage of. The 706, or that federal estate tax return, creates a paper trail for the IRS. It's where the decedent's trustee can disclose the value of the assets passing at the decedent's date of death. So now we can calculate basis for step up purposes. So we get a step up in basis for the value of any assets that are included in our decedent's estate. So then if the surviving spouse or other beneficiaries later dispose of the assets that were included in our decedent's estate, they can really mitigate their capital gains tax liability. And this creates a place for us to document the value. And if no assets are elected on Schedule M, if we don't file a 706, then the assets are simply held in a credit shelter trust, again, usually for the benefit of the surviving spouse, usually subject to the surviving spouse's administration as trustee. It's just a matter of, did we take the tax election or did we not? Again, lots of different pros and cons of that specific issue. We're not going to get into that right now. So some of the perceived cons here, as I mentioned just a moment ago, the Clayton election does require a 706 to be filed in order to make the election. Again, remember, the Clayton election refers to the Clayton case that gave us the strategy to allow a trustee to make an election on an estate tax return for what is subject to the marital deduction and what is not. That's all it means. But if you're going to file the 706 and make the election and claim your portability, there's an expense that's associated with that. So you just have to be upfront with the client explaining that process. Again, I think the pros outweigh the cons on that. But again, it's up to the client to make that decision. Now, if no 706 is filed, if we don't file the estate tax return, there is a theoretical possibility that we send too much money into the bypass trust, potentially triggering estate tax liability. I just think that's extremely remote possibility. If we've got a large estate, or if we've got lots of prior gifts by our decedent, then we're going to be filing a 706 anyway. So I've heard this as an objection to the Clayton election, but I just don't think it holds water. And finally, the Q-tip trust, as I mentioned, it does provide better protection both for the surviving spouse as well as for the protection of the inheritance of our downstream beneficiaries, kids and other people. But it does require more management. Certainly requires more administration than just letting the surviving spouse do whatever the heck they want to with the property and transferring the property outright. Although that might seem attractive to the surviving spouse, it's actually a pretty bad idea because now we have no protection around the assets for the surviving spouse, making the property subject to the future creditors of that spouse and all the other stuff we talked about. At any rate, here's my contact information. I hope this has been useful. Please feel free to insert some comments down below, or if you want to reach out to me on LinkedIn, give me some ideas for additional topics if this is useful to you. Otherwise, have a great day.